evening, everyone, and welcome. My name is Kyla Hannington, and I'm the Public Outreach and Engagement Division Manager with the Prince George's County Office of Human Rights, the county's civil and human rights education and enforcement agency. And with me tonight from our office is Jose Villegas, the Executive Director. And it is our pleasure tonight to welcome you to another in our U.S. Constitution and You series. This time we are focusing on the 4th, 5th, and 6th Amendment. And we are joined again by our special guests, Renée Battle-Brooks and Gabriel Christian. It is once again our honor to have them here with us to help us do this deep dive into the U.S. Constitution and You, what it means for the country, what it means for us, and its ongoing and really important relevance for today. I want to just let people know we're going to be putting comments in the chat. Please chat with us. You are welcome to talk with us. We'll share your questions or comments with the guests if we have time. And if you're watching on demand later, make sure that you check that live chat feature so you can see if we put links in there or things for you to check out when you have a chance. We're really glad that you're here with us. So welcome, Gabriel and Renée. Thank you so much for being back with us.
Thank you.
Thank you. It's an honor.
So we are here to talk about the 4th, 5th, and 6th Amendments. And so I guess I have so many questions and so many things to talk about, but let's hear from you. Can you introduce them to us?
Gabriel, you go first.
Well, I would defer, but since you put me on the spot, so I'd like the listening audience to know that I first met Renée Battle-Brooks in the courthouse, where she was, I believe, initially perhaps a public defender and later on a prosecutor. And for attorneys, we play a very critical role in the protection of civil liberties. So when you talk about the 4th, 5th, and 6th Amendments to the U.S. Constitution, you're talking about the bread and butter of lawyering in the criminal defense or prosecutorial domain. What is the 4th Amendment of the U.S. Constitution? In essence, it protects against unreasonable searches and seizures, right? It requires law enforcement to have a warrant based on probable cause to search or seize property. A police officer can't just stop you and search you, can't just come into your house and search your house, can't just open your vehicle and search your vehicle. They've got to have a warrant. Now, there are exceptions to that rule, the 4th Amendment rule. For instance, a police officer stops your vehicle for speeding, and when he knocks on the window and you roll down your window, he sees in the middle between the two seats a firearm. Well, at that time, he has a right to take you out the vehicle and conduct a protective search, secure you, and then secure the firearm. And if you don't have a permit, then you're in trouble. Because if you're to carry a firearm in Maryland for certain, the rule is you have to have it unloaded in the back of your car, in the trunk of your car, and you can't, of course, be just running around with it. You've got to be going to or from the gun range or to or from your gun dealer and your home. So there are exceptions to the 4th Amendment, but essentially it protects against unreasonable searches and seizures, okay? The 5th Amendment. We hear people say all the time in the movies, I take the 5th. What essentially does is that it guarantees your right against self-incrimination. Okay, it ensures that process and protects against you also being tried twice for the same crime. It's called double jeopardy. So it has this thing where you have a right to assert the right to remain silent in a trial, or you cannot be compelled to testify in a trial where you are the criminal defendant. Okay? If you are stopped on the road and police officers begin to interrogate you, you can say, I assert my right under the U.S. 5th Amendment, and you can...
I just have to jump in here because I would just like to say for the audience, I'm 52 years old, and this is the first time that I knew that I believe the 5th was a reference to the 5th Amendment. And so I'm saying that in case anybody else is watching and they're like,
okay, Kyle, we're going to pull your card.
Well, we can now see the benefit of this type of conversation.
I'm currently saying something that I remarked upon in one of the programs we had where Renée was the interviewer and we were the interviewees, myself and Judge Sean Wallace, where I remarked that in because of the ubiquity of U.S. movies, right? U.S. movies are all over the world. People will hear the term and they will use the term even in countries where there's no companion amendment. Canada might be one of those. But
Right. Thank you.
so
That's
Hollywood,
right.
yeah. So Hollywood has made that an almost universal, term. I take the fifth, and everybody understands what it means that you're not to say anything. So, Kyla, I really am happy you made that comment. And finally, the Sixth Amendment of the U.S. Constitution ensures the right to a fair trial, including the right to counsel, the right to confront witnesses brought against you, and the right to a speedy and public trial. And of course, my dear friend, attorney Renée Battle-Brooks will go into the details.
Yeah. So awesome. So, I did a little bit of a dive. First of all, just some of the background as to how these amendments came about and why, what was happening. So for the Fourth Amendment, well, first of all, as we talked last time, the Bill of Rights that were the first 10 amendments that came about, that was as a concession to get the states to sign on to the Constitution, because there were certain things that they wanted to ensure that we protected, because we were coming from under the tyranny of the British, right? So what was happening, apparently, I didn't know this, but the Fourth Amendment, the right against unreasonable search and seizure, as Gabriel has said, British people actually had that right. It was only because we in the colonies didn't have it, and general warrants were against the law in England, but they were using the general warrants, meaning there was no specificity, against us, the colonists, because they were using like writs of assistance, which were like general warrants, but they were doing it because they were trying to curb our smuggling and our illegal trading. And so they're like, this is how we're going to nip it in the bud. So I thought that was interesting. So yes, so the Fourth Amendment, just as Gabriel says, it does have many parts, but that's where we get this whole probable cause notion from 1791, like the words, right? The parts of the Fourth Amendment, you have to have a neutral and detached magistrate or judge who issues it. So if you're following some of the national dialogue that was occurring, particularly 3 or 4 months ago, with some of the issues occurring in Minnesota, and some of the federal agencies going into people's houses and taking them out, but they didn't have that warrant. And that whole discussion was, what's happening? Is that legal? Is that not legal, right? Sort of the warrants under the Fourth Amendment. If you're going into somebody's house, your house is so sacred. It's the castle doctrine, which actually existed in England from the 1600s, but they didn't apply it to us because we were the colonies. We didn't have those same rights and privileges. So under the Fourth Amendment, as Gabriel said, this is the bread and butter of all attorneys, whether criminal attorneys, whether you're on the defense side or the prosecution side, because this is what gets litigated. So yes, it requires that if you're going to search a place or a person, you have to state with specificity. You have to be very clear about what it is. You have to have probable cause, not a fishing expedition, not I have a hunch or I think. You have to convince a neutral person who has nothing to do with the case, i.e. the magistrate or the judge, that you have credible evidence, and it is to the standard of probable cause, that this person or this place has this particular thing, not let's just go and look and see, right? So it becomes very, very, very complex. What's interesting, and Gabriel will remember this, like I would say the mid 2000s or the early 2000s, like we would litigate if officer legitimately had a cell phone of someone under a search warrant, you could go in and open it up and search and get all the evidence. The court started recognizing that cell phone carried your entire life. It had all of your privacy things, because with this Fourth Amendment comes this expectation of privacy. And so they pretty quickly shut that down, saying, no, if you get that cell phone legitimately in a search warrant, you need another search warrant to look into it, because they have started to view that as sacred as your house. Like you have such a reasonable expectation of privacy that that phone has everything on it, not just maybe that small little thing that you need. So that is protected now. It has all of your pictures. It has everything. Also, in the early days, we were able to get warrants and get, pinging from cell towers to see where you were. They have now shut that down. Like you have to have a search warrant to be able to track the location data of a phone and a person. So it's really interesting how technology has evolved and how the Fourth Amendment is catching up, right, to protect, because the whole basis is an expectation of privacy. Just one more thing really quickly. There are about 10 exceptions. So really where the law says is that you must have a search warrant if you're going to search a person or a place. That search warrant must have particular things in it. We don't have time to go through what all those things are. But one of the things is it must state with particularity. So the law says that if you get something without a search warrant, where they're going to look at is that it is unreasonable. And if it's unreasonable, it's getting suppressed. But there are 10 exceptions. One of those is plain view. That's what Gabriel was talking about. There's something called the Carroll Doctrine, which is a car that moves. And if you have probable cause, it's unreasonable to expect an officer to go because that car will be gone and the evidence is gone. There are exceptions like the impound. Sorry, go ahead.
No, the exigent circumstance. Somebody's running away.
Exigency, exactly. But exigency only is for things like an emergency where somebody's life or could be in peril, or hot pursuit. But it's hot pursuit of not just any crime. It has to be a felony, right? And there, hoops you have to jump through. There are exceptions, for example, for, of course, consent. If somebody consents, then that's fine. You don't need probable cause even. You can ask anybody. So you see on some of these live shows that used to be like they'd ask after a traffic stop, sorry, mind if I search your car, right? If they said yeah, then okay, you can say no, but not everybody knows that, right? That's one of the exceptions. Search incident to arrest. As soon as somebody's arrested, you search them totally. You search anything within their grasp, their reach, their wingspan, you call it. So anyway, these are just some examples. If you impound a vehicle, you have to search that because you're doing an inventory of that vehicle to protect yourself, the agency, and to make sure there's nothing in there to hurt before you tow it. So anyway, there are lots of things. So that's the fourth. Anyway, and then I'll go on to the fifth. But Gabriel, you wanted to say something.
No, go right ahead. I was going to say that what you kind of gave as a factual or historical predicate was what was going on prior to 1776. It was the breaking into houses of the colonies by the British Army folks. That was frowned upon, and also people being forced to give statements, being, interrogated very brutally and forced to give confessions. Star chamber type deals. So all of those, and this is really important to understand. On one hand, you have the presence of a slave state. But then within the revolutionary cohort at the top, you had people like John Adams. And John Adams said something that I think it's worth reminding our listeners of, because he was the first president not to own slaves. He argued against slavery from the outset. And it's interesting, John Adams and who was the president later on, and his son, they were both involved in the defense of the enslaved Africans who had broken out of their chains aboard a ship called Amistad. And they washed up on the shores of, I think, Massachusetts. And they were tried and they were represented by John Adams and his son. And John Adams has this very important statement. And he says, the U.S. Constitution is only suitable for the governance of a moral and Christian people, no other. Let me repeat what he said. The U.S. Constitution is suitable only for the governance of a moral and Christian people, no other. What he essentially was saying is the Constitution is only as good as the people over whom it presides or holds sway. And so if people are immoral, if they don't have any Christian virtue, they're just going, right? And that is why you have defense attorneys, because we have discovered that not all those who are sworn to protect and serve.
Yeah.
They oftentimes have been found to violate the law. And so that then brings us to, the issue of the Fifth Amendment, the right against self-incrimination. I had a situation when I was a young lawyer. There was a shooting at a high school during a gang initiation. This young lady was kept incommunicado at 14, no parents, and no water, no food, and she was interrogated. And my argument was that was coercion. And it was unreasonable to expect her at her tender age to have a sense of her rights. But it was a school-linked shooting, and the public sentiment was so inflamed that the judge in question, I won't call her name, overruled me on my motion to suppress the confession. The police officer said to her, listen, your partner's already confessed. He said you were involved. And that is typical interrogation technique. So you might as well just tell us what you did. How many times did you stab her? It just says tell us, okay, you don't have to tell us you stabbed 6 times. Just tell us you stabbed once, and we'll take you to McDonald's, and we'll get you a McDonald's hamburger, and we'll bring you home. And she says, okay, I stabbed her once, but I didn't push the knife that very fine side. And okay, can I go home now?
That's a clear violation.
Well, I was overruled, and the motion to suppress was not granted. And she did about 25 years. She's since been released. Okay?
So did it go up on appeal and they affirmed it?
Yeah, that type of thing.
Interesting.
But things are a little better.
That was an inducement.
Yeah, things are a little better. Right now, what you have oftentimes in interrogation rooms is that you have a little birdie on the wall. You have a CCTV. Yeah. And the CCTV has been very helpful in protecting civil rights, civil liberties, because when the police officers are talking to the arrested individual, all of that is tape recorded. So the defense attorney in discovery, we will get that information. That's right. And we can discern from that, for instance, whether or not there was a violation of the Fifth Amendment right. So in one particular case, my client was arrested and he was incarcerated, and it has been filmed, and he asserted his right. The police officer gave him his Miranda warning, essentially saying, and Attorney Battle-Brooks will tell us about Miranda in a moment, that anything you say can or will, it's a U.S. Supreme Court case.
Yeah,
Miranda versus Arizona, if I'm not mistaken. Yeah. And basically, if you anything you say can, the famous words, right? Kyla, I'm sure you remember those words from TV.
Well, we don't know whether she remembered those words. She might be quoting something in the movies.
The movies have that part right. Yeah, the right to remain silent. Anything
not applicable in Canada.
The right to an attorney. If you can't afford one will be provided for you. That's
Indeed.
correct. But so
they told him, and he asserted his right. He said, I want to speak. I want to wait for an attorney. I want to speak to my attorney. And so we see on the TV or the film, the officer leaves the room, and my client is in there talking to himself, and he's obviously, exasperated, and they keep him waiting for about half an hour. And then another police officer comes in, not the first one. Mm-hmm. And he says, hi, good evening. How are you doing? Is everything all right? Okay, now let's see. Let's talk about this thing. And he does not reference that this gentleman had earlier on asserted his right. Mm-hmm. And our client basically starts to talk, and that's used against him. And we moved to suppress, and that was granted.
Yes, because that's a very clear
basically violation. Once the door has been shut, by your assertion of that right to counsel, it cannot be reopened. So the words of the wise is, once you assert your right under the Fifth Amendment of the U.S. Constitution to remain silent, as anything you say can or will be used against you, that right, once asserted, has to be respected, and all questioning must stop.
Only the suspect can, if the suspect re-engages, then it's on, right? So a couple of things. So the Fifth Amendment, that is one of the things, but the Fifth Amendment also provides for grand jury. That's where it comes from 1791, that in order for the government to press or to proceed against you in, they were called infamous crimes. We're talking about really felonies and serious crimes. It has to first go through a grand jury, and a grand jury are citizens that listen to the case to determine if there's probable cause to have this case go to the court where felonies are heard. So that's the first part of the clause of the Fifth Amendment. And then, yes, it is self-incrimination, as Gabriel said. That's the Fifth Amendment. It is double jeopardy. So you cannot try a person twice for the same crime. But if it's in two separate jurisdictions, that does not qualify as jeopardy. So if there are two states that have this based on the same facts, but something happened here and there, they can be tried twice, right, under the same facts, but in two separate places. Or you can have state and federal, the same facts, that's not jeopardy. Or the famous illustration is O.J. Simpson, where he was tried state for the murder of his wife and Goldman, found not guilty of murder, and then the family brought a civil suit for wrongful death, which is the civil analogy to a homicide. That was not double jeopardy, and he was found liable there, right? So the double jeopardy clause, there's also part of the Fifth Amendment is that a due process, that the government cannot take your life, your liberty, or your property without due process. So the process due you in court or a hearing, they can't do that. And they also cannot take your property in something called eminent domain without just compensation. So Miranda, my Miranda rights, it comes from the Fifth Amendment, but it comes through something we call case law. There's case law, there's statutory law. So case law, 1966, Miranda versus Arizona. It actually was a case where Mr. Miranda was accused of picking up a woman from a bus stop, I believe it was. He took her out to the desert. He brutally raped her, came back. He was identified, picked up, I think, like the next day. I don't remember all the details. And in 1966, see, before that, there was nothing called the Miranda rights. It came from this case. But there was the amendment. But this is, they finally kind of explained how, because you have to freely, knowingly, and voluntarily waive this sacred right against self-incrimination. It is sacred. So what the police had was they had a form that you waived your rights, and it just had this paragraph, and it said something like, I understand that I have the right not to speak, and right. And so he confessed. They went in, waived, gave him this form, came out, I think, within 2 hours. Went to court. He was found guilty. He appealed. It went all the way up to the Supreme Court. And the Supreme Court said, look, this notion of Miranda cannot just be pro forma. You can't just slap a paragraph on a form and assume that they've read it or even understand it. You must actually ensure that people understand it. So when you think about that, it opens up the door for lots of things. Like, how do you go through the Miranda rights to a juvenile, or maybe someone who's mentally a little bit diminished, or maybe someone whose English is not their first language, or maybe culturally they don't understand, right? So courts look at so many things when they see whether somebody has waived their rights freely, voluntarily, and knowingly, right? You have to know what you're giving up. And so court looked through it and they said, yep, no, because you don't really know whether this was knowingly, voluntarily done. So the Supreme Court overturned his conviction.
No, let me, if I might, just a little bit. I do want to thank you both for having this detailed kind of explanation on the Fourth Amendment and how it had expanded now from the beginning to now, including other things, right? But can you touch or Mr. Gabriel touch how this thing now that we know then as the Fifth Amendment, Fourth Amendment, what is protected, how expensive or exclusive was in the time that we had like a slavery, with the time that we had a narrow definition of who a citizen was. Also,
Well, you're absolutely correct. I mean,
That's a
those
great-
rights. So I was having a discussion with the lead cardiac surgeon at George Washington University on my way home this evening. Typically, I've done this at the office. He will remain unnamed, but we're talking about democracy and the fragility of democracy. And he was making reference to Greece. And he's saying, unlike in Greece when there was democracy, I said, stop for a moment. Even in the whole Greek experience, democracy was limited to a certain social strata. The elite Greeks had democracy, and they could argue in the forum, the senators and what have you, but there was no democracy for the slaves. There were slaves in Greece, in ancient Greece. There was slavery, and the slaves were property. So in the United States, for instance, there were no civil liberties for African Americans. The master could go into the slave quarters at night, as they often did, and have his way with his property.
Right.
Okay? He could go into the slave quarters at any time and take what the slaves had without any recourse by the slave, because the slave was property. Remember, under the Constitution, 3/5 clause, right? They're only 3/5 of a person. Those laws did not apply to them, right? As a matter of fact, it came up in the Dred Scott case when Chief Justice Taney, who was a Marylander and a slave owner, said, when Dred Scott had sued for his freedom because he'd been in a free state, that a African American, they didn't use that term, a black person has no rights that a white person is bound to respect. So, Jose, you're absolutely correct. Those rights that we talk about under the 4th, 5th, and 6th Amendment, those rights were not at the founding of the nation applicable to all citizens. They were only applicable generally to white males and maybe females, one can say, but of a certain class, because a lot of white working class people were not able to petition the courts because you would have to get a lawyer. And where are you going to get a lawyer if you're a poor farmer or a poor worker? Okay, the ability to get, and that's why Renée was a public defender. Public defenders did not always exist. They came into being about maybe a century or more ago, and it was decided that, look, at the legislative level, we need to provide counsel free of charge to our citizens because not all of them can afford a lawyer. So
that's not a constitutional right?
Well, it comes out of the 6th Amendment.
Oh, okay.
Yeah.
We're going to get there.
We're not there yet.
Yeah, so the right to counsel exists, as we will get to, but you need to be able to afford that right. It's not automatic. So even when you are arrested and you may not have the financial wherewithal to hire a lawyer, you still have to go through a process. It's not automatic, and you have to apply, and you have to be screened. And if you make more money than the minimal amount, if you don't meet the particular criteria, you could be denied the services of the public defender. And Renée could speak about that with more specificity and detail than I could, because she served in that office and she knows the ins and outs of that process. But your question is very correct. We've seen over time with the rise of civil rights organizations like the American Civil Liberties Union, increased rights for U.S. citizens against unlawful search and seizure, against interrogation and coerced, confessions and so forth. So we are now in a little better place than we were 150 years ago.
But it is interesting because, Jose, your question, such a good question. And when we think about just this one aspect of representation, there really is a whole segment that's left out, because what the Public Defender Service in Maryland and other jurisdictions have, whether it's court appointed, which is different, but it serves the same purpose. DC has that. I can't speak to that. Virginia has court appointed, right? I guess there's a fund, but there is a minimum criteria. I mean, the criteria, the ceiling is you cannot make a lot of money, and whatever it was. And back when I was doing it, I think it was something like you couldn't make more than $11,000 a year. Okay. So that's not a lot of money. But you have a bunch of people, even back then, that weren't making a whole lot more, making up to that. Maybe the household was making 30,000 or 40. But honestly, if you're thinking about hiring an attorney, it's still not affordable. But there's so sort of no. And then really you get into the whole discussion about, well, if, people's property is being taken, or if there's certain things, then, that's also something that we should provide for. I mean, there's lots of discussion. In immigration court, that should be something, right? So there's all of this discussion, but actually the Supreme Court has already ruled that that's not, one of the things that qualifies. So it is an interesting discussion as to,
So wait, when you say one of the things that the Supreme Court decided that that's not what qualifies, what was that?
Yeah.
Immigration.
Right. So there's not. I mean, that would require something different because it would require, would require Congress to decide that that is sort of a critical thing, and that, right, and some of the other proceedings. So really,
and that will be because what we're discussing right now is dealing with criminal, right? Criminal
Correct.
law, and then the immigration, that will be a civil.
Yeah, it's not criminal, and so.
We just have a comment about affordability, right? Affordability is so relative to what you have. This person is saying.
I quite agree, and so there is sort of that gap, but we've come a long way. It's not perfect. We have a lot we have a lot more to go, and I guess sort of the argument perhaps is if you're completely indigent, meaning you really can't. And if you are, working and you have some money, but you don't have a lot of disposable, that different bar associations, and that's when an attorney when somebody finishes law school and has their JD, their Juris Doctorate, they're not an attorney until they take the exam, which is called the bar exam. They pass the bar, and then they are admitted into the jurisdiction or jurisdictions that they have sat for. And then there are bar associations in every county, city, state, and the United States. And so a lot of bar associations, lawyers register with them, and some register as low fee attorneys, meaning will take, on a reduced fee. Some have sliding scale depending on what your income is. So there is a nod, at least trying to catch those, right? Because the worst thing is really to have somebody who's in jeopardy of losing their liberty, which is profound, whether it's for an hour, a day, a week, weekends, right? We shouldn't be cavalier, or life, right? Or death for those that still have the death penalty, right? So there is an acknowledgement that when somebody's charged with a crime, that there needs to be competent representation, because the way the system is designed to work is that you have equally competent pushing from this side, you have equally competent pushing from this side, and it's an adversarial system where everybody presents instead of sort of the British and some of the others in the old days, the sort of what is it called? It's an investigative, but it's I'll think of the term. It's on the tip of my tongue. It's a different process. So ours is the adversarial system. So you push, and the argument is that somewhere in the middle, the truth falls out because it's an adversarial process. So if you have that adversarial process, both sides, right? You don't want somebody who's not represented against this government's attorney, right? Pro se is what it's called when you represent yourself. Now, some people are pro se because they choose to be, either by their delay, or maybe some people think they're gaming the system, but it doesn't work well. But I can say as a prosecutor, I was like, no, I'll agree to continuance. They need to get an attorney. Going against somebody who's pro se is just not good for many reasons. But Yeah.
Could one of you talk about, because we hear like earlier in the discussion we said, okay, the movies, the United States movies in the world, people are now quoting that Take the Fifth, but it's interesting too that to me how compared to the first three amendments that we discussed in the past, that's very like short and very to the point. If the fourth, fifth, and the sixth are very expensive, right?
Yeah, lots of clauses.
Yes, a lot of clauses, and one of that is that just that no one can nor shall private property be taken for
Mhm.
public use without just compensation.
Right.
It's interesting to me that it's embedded in that other rights within the Fifth Amendment. Can somebody talk about the historical? I mean, why?
I think because, I'm sorry, go ahead. Well, I mean, under the British rule, when this all came about, you had the soldiers from England that were just willy-nilly going in and taking food, taking property because they wanted it. They were the government. They were coming in and taking it. And so we as the colonists said, no, we're going to solidify this. Like, we don't want a government that does that. And so if you as a government are going to take something of mine, whether it's real property, real estate, or something else, because it can be anything, then I'm entitled to fair market value. That's what it's saying. It's saying, I mean, that's how it's been interpreted now. Exactly. Just as you said, nor shall be, nor be deprived of, nor shall private property, I'm looking at the last clause, nor shall private property be taken for public use without just compensation. So eminent domain, Gabriel, you can explain. That's usually how we see it. But.
Yeah. So, for instance, the state wants to build an airport. So first of all, former prosecutor and former public defender Renée Battle-Brooks is absolutely correct. It has this particular clause under the Fifth Amendment has its genesis or its roots in the practice of the British Army, even before the Revolutionary War, of requisitioning private homes for barracks for the troops. So the troops would come in and you'd be in your bed and you'd say, look, we're going to sleep here. But 20 of us are going to bounce down here tonight. And they'd fit themselves into your home, right? Those things are not allowed to happen because the framers of the Constitution, having experienced that sort of oppressive weight of state dominion, decided to embed into our Constitution that clause against unlawful taking. So today, if there's a road to be built by a state or a municipality or airport, eminent domain principles apply. That is, the state has a right to take. They've got to do a property evaluation and pay you fair value, and there has to be a hearing, and you have to be paid. You can't just be denied your 5 acres of land or the front of your property because a road is coming through. So there's due process, and of course that's going to come up in the subsequent amendment. The whole idea of right to due process and right to fair trial. Okay, that's you.
But we do have a sordid history on that, right? When we've gone into some communities of color and taken stuff, and there hasn't.
It just came up. I just discovered. I want to say 2 things that I discovered. I discovered that, for instance, Dulles Airport is built on the Black Town. It just came up in the papers within the past 30 days, and they just moved them out.
Yeah.
And the problem was, Jose, again, when the Union Army brought the Jubilee. So the Union Army is the army that fought the war on the side of the North. The rebel army, the Confederate Army, had risen in rebellion because Lincoln had won the election fair and square. They never went to the Supreme Court, file any petitions to say he had stolen the election, as somebody did recently, and he lost all those petitions. Instead, what they did, they shelled Fort Sumter and started seizing federal arsenals and levying war against the United States. So the United States government remained always under Abraham Lincoln, the legitimate government by law, because Lincoln had won the election. And so what you see happening was the African Americans, whenever the Union Army went south and freed African Americans, they would follow the Union Army. And where was the Union Army headquartered? In Washington, D.C. So you had tens of thousands of persons from the South coming to Washington, D.C., and they settled. In those days, it was not as settled as it is today, and they were there for generations. But because they had not purchased the land through a regular transaction and a title, when issues came up, like Dulles Airport, they had no title. And they had no counsel to go ahead and say, well, by adverse possession over years, they had asserted title by that principle, and they were just moved out. So Renée is absolutely correct that, again, a lot of times how vigorously you are able to assert your constitutional rights depends on your financial wherewithal. Okay, do you have to assert those rights? You have to have the money to buy counsel, or maybe have the help of the ACLU or some. Maybe today's days, in today's world, it's better than 100 years or 50 years ago, even some sort of public interest group to help you file a claim to protect your rights.
And I was going to mention, and that's a good point, Gabriel, that you mentioned in terms of having the financial means to fight something, right? Because we know historically in the United States, there have been specific sections of cities that have been used to do interstate roads in some other community. And I think of just one example that I would mention is the Purple Line, right? That we have here in Prince George's County. I mean, the Purple Line was taken fair market value. I don't know what happened, but there was a large number of people that probably had the means to pay an attorney, and it took so long to finish the process in court that the price of the whole project triple or double because of that fight. So, but I mean, we go back to the financial means you just mentioned.
Yes, sir. Yes, sir.
The other thing, just before we move on to the Sixth Amendment, when we're talking about this just compensation, also I was reminded when I was just sort of refreshing myself in preparation for tonight, that it's also, and I'll just take from this great book, actually, it's called The U.S. Constitution, and it is by Melissa Murray. You'll see her on TV. She actually has a podcast, and she's on independent media now, but she's a law professor, teaches constitutional law. And in her book, she reminds me that that sometimes, like when the government takes actions, like regulatory action, that it impedes your particular use of your property. And under this theory, under the Fifth Amendment, you can still go. No one has seized it, but because of what has been taken, an action, a regulatory action, you no longer can use your property the way you intended it. And so you've been deprived of the value of that use of the property. So it's an interesting sort of way of looking at it from a different perspective. It's not an actual taking.
Just before we move on, I do want to say we do have another question just related to this from Dr. Stewart, who's just, I think, making a comment, but I'm going to pull a question out of here, which is, how is fair market value determined? Dr. Stewart notes that it seems like it's determined by an appraisal. 1 year, a house may appraise for $500,000. 6 months later, it may appraise at $450,000. So is fair market value, I guess my question from this comment is, do you find, or does the practice, is fair market value actually fair in practice? That's my question.
Well, it all depends. Very good question, by the way. Oftentimes, the way it works, and that often comes up in eminent domain cases, but it also comes up in civil cases over property upon the dissolution of a marriage. And what will happen is that the plaintiff may go ahead, because if they want to keep the house, they'll try to get a real estate appraiser to show that it's maybe $500,000 when it may really be $750,000. And of course, the defendant will try to get, because they want to get a portion of the equity, they'll try to get an appraiser at a higher figure. And what the court normally will do is the court will go ahead and maybe do a figure in between, the delta. They'll take a figure that's at the median point. Or the court, if there's no decision that can be made, may appoint a trustee. And that's an independent lawyer and they will give that lawyer the right to go out without any reference to the parties who are in dispute to find that figure or that evaluation so that a fair decision can be made. But that was a very good question, and thank you for the person who asked that question.
Yeah, and really, when you think about fair market value, they're not valuing things like your emotional attachment, the fact that this property's been in the family for 5 generations or 7, or you know what I mean. So none of that comes into the fair. I don't think. I don't know, Gabriel. I don't practice.
No, you're correct. I mean, and what they will do is look at what a house of a similar age in way of how long it's been in existence, with similar amenities, as in size, square footage of the home, the amount of bathrooms in the home, the amount of bedrooms in the home, the particular subdivision it's located in, because as we well know, based on where you live, prices may differ. The house in Bethesda with 2 bedrooms and 2 baths may be more expensive than the house in Prince George's County, let's say, in Upper Marlboro, that has 4 bedrooms and 4 baths, right? More amenities, greater square footage, but because of the subdivision it's located in, a house may appraise for more or appraise for less. So those are the kind of factors that may affect fair market value. But essentially, what they look at are market conditions, and they will try to compare. So normally what the appraiser will do is they will try to take 3 houses that were built around the same time with similar amenities, and they will estimate fair market value based on how 3 houses of similar character, make, size, sold in the past, let's say 3 months. And they will combine the sales price of all 3 and divide it by 3 and have an average. And they will use that average as the FMV. That's what they'll do.
Okay, so I know that we're taking too much time on this particular, but I mean, I want to pass to the 6th Amendment, or at least give it some time to discuss it.
Okay, well, the 6th Amendment has multiple clauses. So, and I'll tell you where it came from. So the first clause is what we call the Speedy Trial Clause. That means that when you're accused of a crime, the government cannot dilly-dally, as my British friends say. You cannot delay. You've got to, if you accuse somebody of something, you've got to get in and get out, right? Maryland has the
Hicks rule.
Right, which is like 180 days, give or take. But there are certain things that affected, constitutional speedy rights. It all depends. That when that kicks in, that can take, maybe that's 2 years, and then you fight. Who knows? But so that's the first clause, a speedy trial. The second clause is what we call the right to a jury trial. That's where this comes from. A jury of your peers. Whole other discussion. What does that actually mean, right? Because anyway, there are lots of rabbit holes we can go down. The next clause is the right to be informed of the charges and the nature of what you're accused of. The next part of the clause is the confrontation clause, meaning the right to cross-examine those that are accusing you. And it's been actually interpreted to mean the right to have face-to-face confrontation. Now, with COVID, some of that maybe changed because we weren't face-to-face physically, but I would consider we're face-to-face here. We're just not in the same room. But anyway, just kind of throwing out things, because the confrontation clause, the interpretation forever had been sort of that face-to-face. So we'll kind of see if it evolves. The next clause is the right to call witnesses in your favor. So that's the right to compulsory process, meaning the subpoena power of the court. Like, it's not just the government that can subpoena. The accused can subpoena and compel, meaning make people come in and testify, whether they want to or not. So a subpoena is a court order. It's not like, it's not convenient. That's not right. It's a court order for everybody, whether it's law enforcement, whether it's me, whether it's you, it doesn't matter. Once that subpoena is served, that's it. It's a court order, unless, you can get an attorney to go in and quash it, meaning get it, withdrawn or suppressed, or, a judge gets you out of it. So, and then the last part of that clause is the the assistance of counsel. So there's a Fifth Amendment right to counsel when we're talking about Miranda and the right against self-incrimination. And then there's the Sixth Amendment right to counsel that kicks in. Really, the Sixth Amendment is really all about defendants' rights at trial. Basically, that's sort of the catch-all. So there's a Sixth Amendment. And I mean, honestly, once the formal proceeding has begun against somebody, whether, you know, the formal proceeding can be at different parts depending on how the case arrived. Sometimes the formal proceeding is that indictment from the grand jury through a true bill. Now that's the formal adversarial process has begun. Sometimes it's when the commissioner issues that warrant. But once that starts, then there's a Sixth Amendment right to counsel. So law enforcement always has to be very careful, because if that adversarial process has started and they think they want to go and speak to that defendant, there are going to be issues. So that's sort of the Sixth Amendment in the clause. And the origin story, or how this came about, really is because when we formed this nation, we decided that we wanted an adversarial process, which was completely different from a process that came from England, which was this inquisitorial system where magistrate would collect the evidence, or judge would collect the evidence and then ultimately determine, versus the adversarial, where this side comes in, presents everything, this side comes in, presents, right? So it's a different process. So that's sort of a backdrop.
I just want to jump in and say, I want to say one thing, then I have a question from a viewer. But I'm just so struck listening to this. I mean, this is our third session on the Constitution, that how critical the Constitution is for people who live here to know, and that if it's being not taught,
and it's not,
that ignorance of that serves a nefarious purpose, right? And so for the people, for all of us to know about, just and this one's really hit me maybe more than the other ones, maybe because of this really direct for me, a really direct implication that I can see. And so I just wanted to kind of highlight that. And I'm so grateful that we're doing this. I don't want to take too much time on that, but I just want to put that thought out there. And we have a audience question. Does an attorney have to ask the actual questions the client wants? And can the client ask the questions themselves? Can the defendant use ignorance as an excuse for not having a proper trial? And then Dr. Stewart has gone on to say that she's not sure she's framing the question exactly how she means, but can you work with that?
That's a great question. Gabriel, you go first.
I think it's a very good question.
Yeah.
But that's why you hire a lawyer, because the lawyer has been through school, the lawyer has had to take an exam, and hopefully the lawyer has experience in the area for which he has been retained. Because one of the rights that protects defendants is that right to argue at the end of a trial if they feel that the lawyer was incompetent, is to file a petition for ineffective assistance of counsel. And you can have the case overturned. For instance, you had a lawyer and the lawyer did not request discovery. You had a lawyer, the lawyer did not file a motion to suppress any bit of evidence that may have been procured in violation of law, in violation of the right to have a search warrant be issued before your home is searched. The lawyer did not move to suppress that evidence, which was obtained illegally. The lawyer did not move in limine to, exclude hearsay evidence. He allowed people to go on the stand and say that, I saw John Wilkes Booth shoot Abe Lincoln. Well, that happened a long time ago. I mean, of course, we all know he did shoot. But, other things that rely on hearsay evidence, which is statements taken for the truth of the matter asserted, but made by an out-of-court declarant, meaning somebody was not in court to be cross-examined as to their, truthfulness, right?
Which is your Fifth Amendment privilege, to confront the accuser.
Indeed. That has been compromised. And your lawyer says nothing. Your lawyer doesn't cross-examine the witnesses. He doesn't confront the witnesses. He just sits there. So when the case is over, you've got a right, just so that the questioner knows, the one who asked the question, if the lawyer was ignorant of what his responsibilities were, the defendant is not left to hang out to dry. He has a right, or she has a right, to petition the court to overturn the conviction using the argument that the attorney that they procured was ineffective. He or she did not know what they didn't know what they were doing. They didn't do a good enough job. And many cases have been overturned on that basis. Am I correct, Renée?
No, you're right. But I think in answer directly to the question that she asked, right, at trial, if you have a lawyer, the judge will not allow you to speak because you
That's
have a lawyer.
correct.
So
They can't have two people trying to do the same job. You
Right.
have a lawyer, and sometimes, it has happened to me. The client wants to say something, and they say, Mr. Christian will speak for you.
right. And so, that really comes down to the relationship that a person has with their attorney, right? And so maybe there's discussion before, and like, I want you to ask this question. And you can say, okay, I will, but I'm going to ask it this way, or I don't advise that because that's, right? You don't understand the rules of evidence that we have, or maybe, if we do, right? There's so many things that you may want to happen that a lawyer knows that, no, we don't want to ask that question. That's not what we want to do, right? So I hope we've answered the question. No, you're not allowed to just get up and ask. If you have a lawyer, that lawyer is your mouthpiece, right? You hear this in movies, but that is the truth. The lawyer is there speaking for you. You guys have disagreements. You have to argue, iron that out amongst yourselves. In court, the lawyer is the one that asks the questions, does it all. Lawyers will listen to the input of their clients and hope to persuade them to allow them their professional judgment, right? So, yeah, there's lots that happens.
Well, I have to say we are really at time, unless one of you has a brief. Do you want to say anything else on this? I mean, I'm sure there's a lot to talk about, but
Good.
You're good. Okay, so we are at a time. An hour.
I do want to say before you start that I can't wait for the next one in the fall, because throughout your schooling you hear about the First Amendment, Second Amendment, Third Amendment, Fourth, Fifth, but you just don't hear anything about the ninth,
Seventh,
the
eighth, and
10th, the eighth, or the seventh. So it's like it'll be very interesting to hear about that. Kyla.
So that's our next one, 7th, 8th, and 9th.
7, 8, 9. And so we will be doing this. You heard Jose say that it'd be a little bit of a break. We're going to take a break for the summer, but we will reconvene in the fall, and we are actually looking at maybe trying to do something in person as well. And so we keep in touch with the Office of Human Rights. You can visit our website at civilrights.mypgc.us. Keep an eye there as we will update upcoming events. And we definitely hope that you all will be able to come back and join us soon. And for Gabriel and Renée, thank you so much for your time and your intelligence and just your willingness to talk about this. Because as I said, it really impacted me today. Like, wow, we need to know these things as the populace needs to know and needs to care and needs to be engaged. And when we don't know, when we are not educated about this, that can be used in bad ways. So just say that. I really appreciate this. And so we just thank you for your time, and we hope that you have a great summer. We will see both of you sometime in September, hopefully. Right.
Thank you very much, Renée.
All right.
Thank you.
Thank you.
Have a great summer.
Good night.
Good
Good
night.
night.